Hello everyone, this is Tushar Bhutani with Remax Excellence.
Hi everyone, this is Sid. I'm a mortgage specialist with Mortgage Alliance.
We have Shaunak Mehta and Neetu Sohi from Juriscorp Law Office, and we will be talking to them about estate planning. What is a will and what is the importance of having one in place? Thank you, Shaunak. Thank you, Neetu, for coming out and doing this for us.
Thank you guys, and welcome to our quick chat show here.
Yeah.
So being a mortgage broker, but when I'm doing the discussions, I'm getting into the mortgage signing stuff. A lot of my clients ask, you know what, we're getting into a new property, we have so much equity involved, or we have so much debt, what should we do? When should we get into estate planning? When should we write a will? So I think my first question to you is, what is a will, and what is included in there for if you can answer that for our clients today first.
Yeah, absolutely. So a will is a legal document that allows a will maker to direct how they would like their estate to be divided and who they would like it to go to. The estate comprises of everything you own. So that includes your personal belongings, it includes the land you own, the house you own, all the money in your bank accounts. And so the will allows you to distribute it according to your wishes.
Sure.
And taking care of the people that you love.
So is it just the equity, or is it also the liabilities that's involved in a will?
So
that's a good question.
Yeah.
So yes, your estate involves both assets and liabilities, right?
So it involves.
Absolutely. So just like while a person is alive, they have certain responsibilities, certain obligations, financial and personal both.
Right.
So a will would also involve responsibilities that has been put on the executor in the event of a person's death to deal with their obligations. There could be payment of taxes as well.
Okay, that's a good point to know. Yeah.
Nice, interesting. And what's the importance, Shaunak and Neetu, of having a will in place? Why should one be devoting time and, of course, looking at all the aspects of it?
I think the number one reason is you want to ensure that the people that you care for and love are taken care of. Often what happens is when a person dies without a will, which is called dying intestate, the province and the court system takes over and determine how your property will be divided. And it may not be in accordance with your wishes. It may be completely against what you wanted. And the people you care for may not be taken care of. So having a will in place allows and ensures that your wishes are met. And in addition to this, it also is a great way to ensure that if you have minor children, that they're going to be taken care of as well, and that you're making it clear who you want taking care of your children.
Right.
And also, it speeds up the process in terms of probate. Every estate is going to go through a probate process, except for some exceptions. So it will go through the court system, whether you have a will or you don't have a will. But having a will speeds it up, because the court system is aware then you have a way you want your estate to be divided.
Right. And Neetu, how does one go about writing a will? Is that something you can do it yourself, or do you still have to go and talk to lawyers and there is a process you have to go through?
So there is, a lot of people these days are looking to do-it-yourself wills. They're online, and I see where people may see the value of it because it may not be costly in their mind, but it can be costly in a different way, the way that your estate will be taken care of. So a lot of the do-it-yourself wills lacks some very important things. One is legal advice. There are a lot of legal concepts and issues that you may not consider, and you need that legal expert to give you the information you require to adequately provide for the people you care for and deal with your estate. In addition to this is flexibility. So if you go online, you may find a lot of questions, yes or no questions, but not providing any detailed information about what your estate involves. Often people have complex estates. They may have simple, they may have complex, but the reality is when it's a yes or no question, it cannot really cater to your needs and what your estate will require. Another issue we have found, a very common issue, is the execution of your will. If you don't have somebody who's experienced and executing those documents with you, you may find that it's not done properly. And then, if your will is not executed properly, the court will invalidate it. So essentially you go back to square one and you've died without a will. And that again complicates the whole process.
Great to know this stuff.
Wow, I should get mine done right away.
I guess absolutely.
I guess this is
without
really
a
We
doubt.
all
stuff.
should, right? So
Yeah.
we all have these. We all own some kind of an estate right now,
Yeah.
of course, and this is something we really should consider. We don't spend a lot of time on it
Right.
at an early age, but definitely this is something we should always keep back of our mind.
I agree. A lot of people think, oh, you know what, I'm just 30, I'm just 35. It's too early to have a will in place, but I think we all should have one.
Yeah.
And I totally agree with the statement that you just made, Sid, that is it too early to get a will done, right? It is, I think, as soon as a person is the age of majority,
Right.
and their life changes, right?
Right.
They get into a relationship, maybe they have children, they
Right.
start having some assets.
Yeah.
It is very important to get an expert who can
Mhm.
assist with getting these documents done. It is a very emotional process as well, and we have seen that a lot of clients do get very emotional about this.
Right.
You may or may not make the right decisions when you are emotional about a piece of your estate.
Mhm.
And that is
Right,
where
right.
the expertise and the hand-holding of an expert comes in handy, is very important. And that is why we recommend that talk to an expert
Mhm.
and put the right mechanism in place to secure your loved ones.
Right. So that brings a question to me, Neetu. Let's say I write a will today, and let's say 2 years from now, I have a different set of mind. Can I make changes to that will? Can I, edit it? Can we? Let's say I have another estate that I own now, and I want to take care of that as well. So is it editable?
Yes, absolutely. I suggest to my clients to definitely review their will on a yearly basis. If there's any major life events, as Sean was talking about, you've gotten married, you have children, maybe you're getting divorced,
Right.
maybe your health has changed. You can absolutely go about, making changes to your will. You can update it through use of a codicil, or you can actually make a brand new will. I often suggest that when you're making there are really big changes in your life, you
Right.
do want to have to redo your will.
I see.
Things change, laws change. It's always great to have the most up-to-date estate documents.
Neetu, I've got a question. So what are the factors one should really consider when appointing a personal rep to your will? And who is a personal rep? Just for our viewers, right? They should be knowing what exactly personal rep means.
Right, so a personal representative is someone that you appoint to administer your estate after you've passed. That person is going to execute the will. They're going to do all that's necessary to meet the wishes of your will. When considering, appointing this personal representative, you want to make sure that they are up for the task. It is quite a bit of work, and you want to make sure that they can handle it and do a good job, essentially. So that's something definitely to consider. In addition to that, I would also suggest that you have a backup person. So if the person you've decided to use as your personal representative passes away before you do, or tells you they're no longer willing to do that for you if you do pass, then you want to have a second person that can take their place.
Okay. So it can be changed on the will as and when it's needed.
Well, we would just make sure that you account for if something happens to your first person you've picked as your personal representative, that there's someone that can take their place.
Right.
And often, people may want to have two people work jointly to execute your will, and that's also possible.
Okay.
Wow, so that was great information. Now that I'm considering to get my will done, I think my next question is, who can I appoint as a personal representative? Does it have to be a professional? It can be from my family, or where do we go for that?
Yeah, that's an excellent question, as it is a great responsibility to take on the task of being an executor for an estate. Having said that, you don't necessarily need a lawyer or a professional to be the executor of your estate. You can definitely pick someone from your family, a good friend, even somebody who's benefiting from your will. A beneficiary of your will can also be appointed as an executor of your will. Often people can use different services from different banking institutions. They offer these types of services of being an executor for your estate as well. If you don't have a family member in Canada, that is also an option.
Neetu, moving on. Probate, I know we touched base a little bit on it earlier in the video. I would like to share a bit of my experience. So what really happens is when I get involved in estate sales, when I am either working on the selling side or on the buying side, I get this question asked a lot if there's a probate in place. I know there are a lot of restrictions. We really need to have a probate in place before we can even remove conditions or keep a closing date in the contract. So how does probate really affect the contract, and what is the importance of it?
So probate is, when it's done through it's an application that's made through the court system in surrogate court.
Mm-hmm.
And often the timelines are hard to tell. It can take some time before a probate application is granted. So that's something to keep in mind in dealing with these types of real estate transactions, is you can't always have an exact timeline. It can take time. There are different factors that may affect a probate application being approved.
Right.
And Tushar, you've also seen a lot of offer to purchase agreements where the grant for probate is kept as a term and not as a condition.
Yes.
And so in those cases, as lawyers, we have seen at the time of closing of the transactions that when the file comes to our table and the grant of probate order has not been granted yet or allowed yet, decisions have to be taken at the time to postpone the closing by a few more weeks or sometimes by months as well. So your absolutely important question that probate process could take up to months sometimes, and that process is quite lengthy.
All right, so are there any additional documents other than a will?
Yes, in addition to having a will drafted, we would highly recommend that you have a personal directive and enduring power of attorney drafted as well. These two documents assist you if you become mentally incapacitated and are unable to make decisions for yourself with regards to your health and your finances. And these documents would allow you to appoint someone to do so on your behalf.
One last question. How does it really work with cost and timelines when drafting a will?
So honestly, the process can be quite straightforward once the person has decided they want to get the will done, right? So we have a streamlined process that we follow at our law firm. We have a questionnaire that we have prepared for our clients. And once they decide that yes, they do want to go ahead with getting the estate planning documents in place, we will provide those those questions to them to help them decide on those important decisions and put those processes in place. As far as the timelines are concerned, once we have all the information, we can turn a will file around in sometimes 24 hours as well, because we understand that sometimes there could be a lot of urgency required. Right? We have had certain situations where Neetu or myself, we have had to visit a person while they were hospitalized. Right?
Wow.
So that is something that is extremely can be extremely time sensitive. As far as the costs are concerned, the cost for a will package, as we call it, for a couple, we have a standard fee. Those fees could be less than $1,000.
Wow, less than $1,000? That's really good. I always used to think, you know what, getting a will done, going into a lawyer's office to get it done would cost me a fortune, but I think that's very affordable for all of us here.
Well, I guess it's in fact the other way around. If you don't have a will in place, if you don't go and talk to a professional, it can be really expensive for you in the other sense. If you don't have one in place, right? Wow, this has been a great topic, Sid.
I agree. I've learned so much. I've enjoyed this discussion so much.
Great learning for us. Thanks again, Sean, and thanks, Neetu, for coming out and doing this for us. Great information for all of us, for all the viewers. And if you have any more questions, feel free to reach out to us or contact Juriscorp Law Office. Thank you.
Thank you, guys. Have a good day.